Good morning. I'm Harold Oler of Oler Mediation. I'll be your MC today, and it's my pleasure to welcome you to our presentation entitled True Confessions, Part 1, What Trial Lawyers and Their Clients Really Want from Mediators. We have a very impressive panel to dish the dirt on what trial lawyers, in-house counsel, and their clients like and don't like about the mediation process. Joining me on our panel are four outstanding attorneys, three trial lawyers, and a prominent general counsel. Anitra Raitford Clement is a partner in the product liability, class action, and complex litigation practice groups at Shook, Hardy, and Bacon. Anitra has a national litigation practice involving claims related to consumer protection, product liability, trade secrets, warranty claims, as well as personal injury and wrongful death disputes. Anitra has been peer recognized through Best Lawyers, Florida Super Lawyers, and Florida Trend. Caitlin Jamo is a partner at Johnson Pope and splits her practice between probate litigation and general commercial litigation. She is the immediate past president of the Clearwater Bar Association and is an advocacy skills trainer at Stetson College of Law. She's been recognized by Best Lawyers in America and named a Super Lawyers Rising Star. In her spare time, Caitlin is an accomplished actress and singer in the Tampa Bay area as well. I had the good fortune to catch her in a show recently, and she was terrific. Effie Silva is the Senior Vice President and General Counsel of Fresh Del Monte Produce. Effie leads the company's legal, risk management, compliance, food safety, government affairs, and corporate reporting functions. She joined Del Monte after a successful tenure as the Ethics and Compliance Leader for Cargill, Inc., and is Vice President and Associate General Counsel at Tyson Foods. In addition to her tenure as an in-house counsel, Effie has 20 years of complex business law practice experience at prominent global law firms. Shireen Vesley is a partner at Trenum Law. Shireen's practice involves business litigation, personal injury law, wrongful death, nursing malpractice, legal malpractice, and employment litigation. Shireen is also a Florida Supreme Court certified circuit civil mediator. Shireen serves on the executive council of the trial lawyers section of the Florida Bar. With all of that, she's an adjunct professor at Stetson College of Law, where she teaches trial advocacy. Shireen has been recognized by Best Lawyers in America and Florida Legal Elite. Did you notice how the first initial of our four panelists' names spells the word ACEs? This is very fitting because they are our four ACEs this morning, and you will love hearing what they have to say about the mediation process.
To round out our panel, our MC extraordinaire, Harold Oler at Oler Mediation, has sat in every seat in the mediation room. He served as a trial lawyer and tried many cases to verdict, including a successful 17-week jury trial, which has the longest personal injury jury trial in Pinellas County history at the time. He then spent 21 years in the client seat as the general counsel of a national automotive retailer, where he managed the company's litigation and attended all mediations and trials across the country on the company's behalf. As a mediator, Harold created the Florida Mediation Best Practices Handbook, which is used by lawyers, universities, and law schools around the state. In 2022, the Florida Bar's ADR section awarded Harold its MVP award for Harold's work to bring trial lawyers and mediators together across the state of Florida to collaboratively improve the mediation process.
Thanks so much. Thank you. As a full-time mediator, I'm continually surprised that mediators never ask their clients, what can I do better? There are no Yelp reviews for mediators. So when I served as chair of the mediation section of the Hillsborough County Bar Association, we started polling trial lawyers and in-house counsel all over the state of Florida and we had meetings like this one to provide trial lawyers, mediators, and in-house counsel a platform to improve the mediation process together. We compiled the very best mediation strategies for trial lawyers and mediators collected from hundreds of attorneys into the Florida Mediation Best Practices Handbook, the first such guide in Florida history. The handbook is included in your course materials today. After we hear from our four ACEs, I'll finish the discussion on each of the 5 topics by drawing from the handbook, as it represents the voice of the mediator's customer. I'll even share some new information from the upcoming third edition of the handbook before it's released next month. I'd like to thank Anitra Clement, who also serves on the editorial board for the third edition of the handbook with me. So now, let's dish the dirt on what trial lawyers and in-house counsels secretly want from mediators. Here's our first topic. What are the qualities in a mediator that makes you hire them again? In other words, what separates great mediators from good mediators?
Harold, thanks for having us. And as the A of ACEs, I get to answer this question first. So I'm very result driven, and I think my clients are too. Obviously, if a mediator can resolve a case, that puts them at the top of the list to be selected again. But I recognize, especially in the sophisticated work that I do, especially in like the products liability and class action spaces, sometimes that just isn't possible. So in those situations, I expect a mediator to help narrow the issues. I can think about a case that I have right now where the complaint is like, almost 200 pages or something ridiculous. And, of course, we have dispositive motions on file and, maybe we're going to narrow the issues. But by the time we get to the mediator, I need the mediator to help us narrow the issues further to help streamline everything for trial.
Thank you.
So I would say in my probate litigation world, my clients often care less about the results. It's not the destination, it's the journey a lot of times for them, because it's a very heightened emotion, often a very heightened emotion case for them. It has to do with decades likely of family experiences and emotions and trauma in some instances. So for them, a lot of times it's just feeling heard in that moment. So for me, a good mediator is someone who I know is going to either have a hardball style or another one may be great at listening. And I'll pick based upon what I think my client needs in that moment. But a great mediator in my probate litigation practice is someone who has the flexibility to do any of that based upon what my client needs. Sometimes it's multiple things all in the same mediation. Sometimes they need hardball as well as to feel heard. But I've often had clients who haven't been successful in the mediation and haven't had the result I would want, but still appreciate the experience in mediation because the mediator made them feel heard or because of the flexibility that he or she had in that experience.
So I just wanted to say I'm so humbled to be with this crew of ACEs. And Harold, thank you so much for the invitation. And I hope that the audience gets as much out of this as we had in the pre-workshop leading up to this discussion. But I think what separates it in my mind and from my experience is really the creativity of the mediator and the listening skills. And that might sound very basic, but it's absolutely critical to what separates just a regular mediator from a superstar. I think the other factor is really knowing either the state laws, the province laws, or the local country laws, if it's an international mediation. I do a lot of work globally, so there's always that facet. That's what separates it for me. And just again, it's the listening skills, because you can tell the mediator what you want, and sometimes mediators go on their own path in interpreting that, which can lead a mediation to go awry.
Good morning, everyone. Again, Shireen Vesley here. It's a privilege to be with this very talented group, so thank you for having me. I will hire a mediator again if I see this. Is he or she the type of person that will roll up their sleeves pretty quickly and figure out the personalities in the room? The personality of the client, the personality of the lawyer, and the dynamics between them. Sometimes there are clients who have hardly any tolerance to hear anything negative about their case. So that person has to be dealt with a certain way by the mediator. And then on the flip side, you have a client sometimes who wants a second opinion, wants to know all the things that could possibly go wrong with his case. And so you have to have a mediator that will be in tune with that as well. And I think you also need to understand the dynamics between the lawyer and the client. Does the lawyer have any control whatsoever over the client? Does the client respect the lawyer? Does the client, will the client take the lawyer's advice? Does the lawyer need some help in the room, some strength to help the client see? And so I think I think a successful mediation really requires a mediator who is going to quickly gauge the personalities and the dynamics between the parties and then adjust accordingly. Because, there's no caucus room, there's no two caucus rooms alike. And I think the more flexible and malleable the mediator can be, the better off we are. And so that's kind of what I look for.
Thanks, Shireen. I had the privilege of hiring mediators for 30 years before I became one. And in my view, a good mediator is one that understands the law. But a great mediator is one that understands the people, to Shireen's point. To do that effectively, I contact every lawyer before every mediation to learn everything I can about the parties, their particular objectives, and the circumstances that make the decision makers more or less likely to settle. This allows me to create a detailed settlement plan for each decision maker before we start the mediation. I try to begin every first caucus with each party by asking each decision maker, what's on your mind after you heard the lawyer's presentations? This unlocks an unbelievable amount of valuable information. One of the most important things a mediator can do in caucus is to ask the right questions and then just be quiet and listen. Talking to decision makers comes pretty easy because I spent over 20 years in the decision maker's seat in mediation. And I talk to decision makers like when you meet someone from your hometown and you have a lot in common. But the good news is you don't have to spend 20 years attending mediations in the client seat to do this. But you do have to learn everything you possibly can about each decision maker before and during the mediation. The ability to understand and connect with the parties and their lawyers, in my view, is the most important thing that separates great mediators from good mediators. Topic number 2. Thank you all. That was excellent, those points that you made. What do mediators do that drive you crazy? Anitra?
I just don't like it when mediators are not as prepared as I would like for them to be. I feel like if I'm going to provide a mediation statement, which will more than likely be very succinct and, in my opinion, helpful, that they have read it and understood it. And to the extent they have questions about it, reach out ahead of time. I don't like when the mediator is spending the beginnings of the process learning about the case when they could have been prepared before, we started the process on the day of.
Thank you.
So from my perspective, it's sometimes when mediators will maybe not be cognizant of the relationship between the attorney and the client. And what I mean is, I love mediation often as one of the first times where someone who's really getting into the weeds of the facts and the law in the case can actually spar with me a little bit. And frankly, sometimes that's beneficial for my client to see me advocate on his or her behalf in response to questions and factual questions, legal questions that the mediator has. So sometimes that's beneficial. Where it crosses the line into not beneficial is if there's too far or too aggressive of a question in terms of legal issues that I may have absolutely thought of, and there's 6 reasons why I didn't do it that way. But if the mediator isn't thinking in terms of how is the client perceiving this interaction, that can then cause my client to start to question my credibility, and then I have to spend a lot of time explaining this is exactly why we did this, or remember this is exactly why. So certainly love the sparring, love the pushback, but I would be very cognizant of, are you undermining the client's credibility and the attorney in your communications with them?
Thanks, Kayla.
Yeah, so I echo actually all those points, and really it drills down to 2 things, is going back to my not listening. And that really you can really tell with the mediator at the pre-conference point, pre-mediation point. Normally, a good mediator gives you a call as the other side. They've already read the briefs. They've read the mediation statement that you paid for outside counsel to write. And let me tell you, if they're not reading it, it's a big red flag. And the other thing is the pre-questioning, right? Like, let them get into the details of what I'm looking for, not through my attorney, but through me. The questioning, what I want to affect from the mediation and what direction I want to go in. And that's back to the listening skill. That's so vital. So I think the pre-mediation is almost game day, right? It is almost the game day of how you want it to go.
Yeah. Thank you.
So I echo the thoughts that have already been said, but let me also say what drives me crazy is when I get a messenger, not a mediator. And I do think that there are a decent number of mediators out there who read the rules so strictly that I think they kind of become a little paralyzed in mediation. They feel like they really can't give opinions. They feel like they can't engage. And I've seen this a few times, and it makes the session pretty useless. And I find myself having to play mediator and having to, specifically ask the mediator to do certain things and say certain things in order to try to make the process work. And so that has happened to me, I would think, at least on 3 occasions that I can remember. And I just think that is not the intended thing for a mediator. I think our rules need to be read in a way where we can actually engage and be effective.
When I hired mediators for 30 years, I found that mediators were like baseball pitchers. During the first few years I started working with them, they would tirelessly work until a case was settled. But then after a few years, it seemed like all of them would eventually lose their fastball. They weren't as passionate. They impassed cases more quickly. They would just shrug and say, that's all I can do, when I knew there was a lot more negotiating that could be done to get to the party's real bottom lines. There are basically 3 numbers, and we talk about this in the handbook. There are 3 numbers that every decision maker has in a mediation: the number they want, the number they'll settle for, and the number they won't walk away from. The mediator's job is to use every technique in the mediator's arsenal to bring the parties closer and closer together until they're both in that zone of tension where neither side will walk away. When you lose your passion for helping the parties work through that journey, when it becomes a chore to really deeply get to know the decision makers, it's time to hang up your cleats, because every client deserves a fully engaged and committed mediator. Topic number 3. Tell us about a technique a mediator successfully used to settle a case that appeared hopelessly headed for impasse.
A few years ago, I had a business litigation dispute here in Florida where the parties were very emotional about the breakdown of their business relationship. And we saw that throughout the litigation in the drafting of the motions and the responses and just all the interactions. And to Sharon's point earlier about a good mediator being able to read the room and understand the emotions and, different players that are participating in the mediation, I saw this mediator do that. And I think on that day, we probably could have, gone to impasse because of all the heightened emotions and people getting all up in arms about opening statements and things like that. But clearly the mediator saw that we were closer to a resolution that everybody would be happy with. And what he did was he asked our client if we would be willing to make it the other side's idea. And we were, because we just wanted the result. But I realized that mediator understood the relationships and the dynamics. And he understood that if I can get the other side to say this is their idea and we accept it, then we're going to able to, have an agreement and move on with this case. So that was really helpful, and I really appreciated that thoughtful approach.
Thank you.
My story actually follows suit, and it's happened a number of times. One specifically comes to mind, but it's where the mediator has been hyper aware that the source of an offer or the source of a comment, those types of things are particularly emotionally important for clients and high emotion issues. I found that brackets can be very effective to avoid an impasse. And in particular, I've had a mediator from from a mediator's proposal standpoint say, if I offer this or this bracket, do you think you'd accept it? Can I start maybe broaching it with the other side? And because the source was not the other side, and because the source wasn't us, probably from the other side's perspective, everyone was willing to then narrow down the issues to this bracket and then ultimately was successful. And it was this emotional intelligence that allowed that to be successful. So pretty similar to what Anitra said.
Thank you.
So I had an experience actually in California, not in Florida, where it was, again, the creativity of the mediator. We were definitely heading towards an impasse. And he came up on his own with the tax implications on the corporate side. So he made it easier to make a decision based on the implications to the corporation for tax reporting purposes that made sense and would actually to inure to our benefit. That it actually settled on that day. So I would say, that's a specific example, again, going back to knowing the local laws, or at least whatever, if it's not the laws and you're not an underlying lawyer, because I've seen some of the chat, I would say just knowing, your jurisdiction's understanding of the industry and the specific levers that you can pull and push to get to yes.
Fantastic. So a mediation that I had very recently, a mediator did something in the end, which I now consider brilliant. This was a case in which it really involved 3 circuit court cases and 2 arbitrations. It was a business divorce, very emotional. These owners of this business were like family, and then there was all this betrayal, and it was very, very emotional. Case went on for 3 years. And we'd already had a mediation a year and a half ago, which ended horribly. And now we were ordered to mediate again. And what happened is we start mediation, and both sides are like, I don't even know. The lawyers are like, we don't even know how this could possibly settle, because the parties can't even decide which way the money's going to flow, much less anything else. And so I even had that conversation with the opposing lawyer prior to, if you can think of anything that we can do to resolve this, I don't see this happening because we can't even agree on which way the money should flow. But we get into mediation. The mediator recognizes it is as bad as the lawyers say. And of course, I don't know what happened in the other room, but he had the intuition to do one more thing before impasse, and that was to put the parties together. Now, the parties were together on Zoom, which made it possible for them to come together. If they were in person, they might not have been able to come together, but they were on Zoom. And because the parties came together without their lawyers and had their own conversation and got through all of the heartbreak and heartache issues, they were able to come together on a resolution. And I really commend that mediator for doing that. I think what that mediator realized is that the lawyer in the other room was holding back a settlement possibility, and he needed to carve out that lawyer to make it happen. And that's what occurred. So I think 2 things. There are times when just the parties without the lawyers can work. The other thing is, if it's you've got a lawyer who just wants to keep on litigating and not have their case settled, try to recognize it and try to work around it.
Thanks, Shreya. I've also seen a lot of breakthroughs in attorney-only and client-only conferences. But I think we might need to go on mute there. But I want to address mediator proposals. We're getting a little bit of feedback. If we could just go on mute, maybe.
Okay.
See. Okay, so I want to focus on the silver bullet. I attended this conference, which is the mediator's proposal. Trial lawyers often call it the silver bullet. I attended this conference a year ago, and I heard a veteran mediator leading a session say, mediators don't have the right ethically to offer proposals. Can you believe it? Nothing could be further from the truth. Rule 10.370 authorizes mediators to draft settlement proposals. And MEAC opinion 2010-006 specifically authorizes mediator proposals where the mediator makes the proposal by asking the parties, would you consider, rather than you should consider, so that the mediator doesn't infringe on the right of self-determination. I had a mediation several years ago involving litigation that had been going on in 3 separate courts for more than 5 years. After a 9-hour mediation, and weeks of telephone negotiations resulted in an impasse, I asked both sides for permission to send them a mediator's proposal, no charge. They agreed, and I asked if they were willing to consider a certain number between the 2 sides' final offers. To everyone's surprise, the parties accepted the mediator's proposal, globally settling the entire litigation in all 3 courts. The responses to our surveys about mediation show that trial lawyers don't want mediators who are merely number carriers or messengers, as we heard earlier. They want mediators that actually offer proposals that the parties and the lawyers haven't thought of, like Effie pointed out, with the mediator that brought up the tax solution. And that requires mediators to work hard to learn the real objectives of both decision makers so they can figure out the solutions to the problems that are actually driving the dispute. Topic number 4. Tell us about your most memorable mediation, good or bad, and why you'll never forget it.
I have to go first again because I'm the A of ACEs, but I'm still grappling with a mediation that I had for a class action in California. And there, it was actually in front of a magistrate judge. The magistrate judge really talked directly to my client mostly and put the onus on my client. I'm a defense attorney, so it's, a company. And the class action is unique in that it is a matter of first impression. And most of the jurisdictions in the United States have not allowed these type of cases to move forward. But, California, it's its own unique, area of law. So it's so far moving forward in California. And I just felt like the mediator put some pressure on my client and said that the onus was on the client to resolve. And maybe that's true. Maybe the plaintiff is not the one offering money here and there, but I'm still dealing and processing what happened, because in the case, of course, the plaintiff is asking for a ton of money, and in other jurisdictions, the courts aren't letting these type of cases go through. So it was interesting. I don't mind a mediator talking to my client directly. I think, as Effie, I think, said, sometimes the in-house counsel knows more about the business, and, and in-house counsel can definitely, provide insight in the process. But I felt like that pressure just wasn't as helpful as the court probably intended it for it to be.
So I have 2 kind of memorable, one that in the end was good, and the other, which was a bad memory. The first one was an estate case where we settled hundreds of thousands of dollars in probably the first 20 minutes of the mediation. But after hours and hours of mediation, we ultimately impassed on the mediation day because the parties who were siblings could not agree what would happen with mom's dining room table, to the ire of every other human being who was involved in that mediation. The good part of the story was that the mediator, again, having the emotional intelligence to know we're not getting anywhere today, a couple of days later reached out to counsel, cooler heads prevailed, and we were able to ultimately resolve what would happen with mom's dining room table. as well as the hundreds of thousands of dollars, which was a non-issue. So I take that as a positive memory of persistence being very helpful, and thank goodness for that mediator for circling back. The negative memory is, and I pointed out just because it's something I wouldn't have thought about as the litigator or as a mediator, was successfully resolving a trust dispute with my client. But my client had zero interest in ever being in the same room as the other side. In probate litigation cases, we very rarely do opening statements because of the heightened emotion, or at least in my experience, we have. So she refused to ever be in the presence of the other side, to the extent that we had to wait quite a while after the mediation settled, after hours and hours, because the glass doors and the other side was remaining in their room and she didn't want to even walk past him. So as silly as that sounds, that was a very real and valid feeling that she had. And so being aware of even things like the geography of the mediation setup, because I was trapped there for quite a while with my client after successfully resolving it, but it's just something to be aware of.
Just want to address some of the chat that I've seen about the tax advice. It wasn't framed as tax advice. It wasn't given as tax advice. The mediator simply said, are there any tax solutions that your in-house folks can think about in light of this mediation? And then literally I pulled in the tax department to the mediation and we were able to work out a solution. So it's just the creativity and the thought of, I just wanted to make sure I circled back that it wasn't like, it was framed as just a kick out a reference. My most memorable was back when I was in private practice. I had a dramatic mediation. And when I say dramatic, the mediator was known to be aggressive. I didn't think it would be this type of aggression. It was blistering. Like, we got in there and within the first moments of the mediation, he was screaming at both sides, very aggressive. Like, we need to get down to, I've read the briefs, I've made my own conclusions, and this is going to be, a Hail Mary long shot, like already framing it to be very, like it was going to result in impasse, and that he was going to make this determination, unilaterally. So, and then when we got into private caucus, I think it was only the first breakout. He was literally challenging my client with all these sorts of questions. Discredit. I was there defending my client against the mediator, believe it or not. So that was the most memorable. It was a bad memory. And I think within like the 2 sessions after the 2 breakouts, he decided on his own that he was going to huff and puff and leave the mediation. So you can just imagine that we weren't paying for those fees. And that was my most memorable moment.
There we go. Okay. I don't know if I can beat that, but I have a most memorable mediation. It was when I represented a party. She was a patient of a psychiatrist. The psychiatrist was married with children. The psychiatrist was using his psychiatry sessions with this woman to engage in inappropriate sexual conduct. And of course, it increased the trust issues that the patient had. It increased the mental health issues that the patient had, exacerbated all of that. And obviously very contrary to the kind of care that she needed.